Here is an area in which courts afford the blundering party utterly no sympathy, and under no circumstances will they afford that party any relief. Where the party is guilty of an error in business judgment, as opposed to a miscalculation in computing the terms of a bargain. If you think about it, errors in business judgment are what makes the capitalistic system work. The reason you're getting up on these cold mornings and slipping on your socks and padding out into the marketplace is the hope that you will find some chump out there who will make an error in business judgment. If in 20/20 hindsight all those deals could be recalled, life as we know it could not be lived. And though parties have often said this is an amoral rule, let the record reflect that I'm unaware that any of us are climbing walls attempting to get into the Czechoslovak consulate. Right? But that is the essence of the capitalistic system, this rule on errors in business judgment. Let me give you an example. Let's look down the road some 20 years. The missus and I are finally rid of all the kids. We have retired from our position as school teachers in Davis, California, taken our modest pensions and life savings and moved to Southern California to join you all. We couldn't afford to come here to Santa Monica. Instead, we're out in Bakersfield, California. Right? And we bought what, until we found it, had been called a junk store in Bakersfield, but of course we immediately renamed it as our Antique Emporium. 20 years have seen changes in your life. You have retired prematurely from a spectacular career as a practicing lawyer in California and have set out on a personal quest. A quest in seeking that Italian art masterpiece that disappeared near Bakersfield at the outset of World War II, the long-lost and fabled Bakersfield Botticelli. Well, our paths are about to cross, because you walk into our shop one day, just about closing time, and you're in the back, and suddenly your heart stops, for there in a tattered frame is your heart's desire. 20 years as a trial lawyer was not for naught. You don't come racing up, panting to the counter. You sort of saddle up to the counter and say, how much would you take for the unspeakably ugly painting? The frame reminds me of something that hung in my sainted grandmother's home. And I go back and spit on a Kleenex and wipe off the price mark, and it's $500. You don't have $500 in cash on your person. We don't take American Express. And you believe Carl Malden, all you have are traveler's checks. We don't do those either. So you do have $100, and you say to me, well, gee, Dan, I'll give you $100 now and come back in the morning with $400. Is that a deal? And I say yes. And that night, I go home, and the missus and I are sitting there on the outskirts of Bakersfield in our double-wide mobile home, in our matching double-knit leisure suits, watching our big-screen TV, when suddenly there's a very familiar face on the screen, Barbara Walters, the million-dollar lady out for one last big interview. And I recognize the person who's next to her, for it is you. Barbara has announced that you have discovered the Bakersfield Botticelli, which she announces you have purchased from an individual she uncharitably labels the Boob of Bakersfield, for a paltry $500. And she invites the world to accompany you tomorrow when you go to pick up the merchandise. Suddenly, of course, there is a loud thump as that bottle of beer, or dare we make it champagne, slips from my grasp. What can I do in the fetal position on the floor? The answer is nothing at all. I must recognize that I am guilty of an error in business judgment. The deal I made with you was the one I stupidly intended. That's the litmus test. And although you knew, you had absolute conscious knowledge that you were taking me for a hellacious ride, I have no defense. None at all. And so we've talked of mutual mistake. We've spoken now of unilateral mistakes. And we have divided them as blunders that are either mechanical miscalculations where there's hope if the other party doesn't have a commercially reasonable expectation, which you surely did not, and errors in business judgment, which, like goodness and Mae West Diamond Collection, have nothing to do with it. I'm stuck. What about the blunders of third-party intermediaries? Right? Here the offeror knew what he wanted to say, but a third party selected as an intermediary in the transaction made a mistake in transmission, dropped a zero out of the price tag as a common one. Well, the rules are identical to the rules applied to mechanical miscalculations. If I selected Western Union as the offeror, then if the message Western Union delivers dropped to 0 from what I had given Western Union to dispatch, whether or not you have a contract predicated upon your acceptance of the telegram you actually received depends upon whether you had a commercially reasonable expectation. If you neither knew nor as a reasonable person had any grounds for suspecting that there was such an error in transmission, you can form a contract. But if you knew this was an offer too good to be true, you have no such expectation, and I have a defense. I have a defense. If I am forced to eat the deal because you do, of course I have a cause of action against Western Union for breach of the contract of transmission, but that's not much of a consolation prize. Now there is one last topic that I want to go over with before we take a break. Well, actually, I want to do two things, because we haven't talked about the California bar exam question for about an hour, and there's a real good one I'd like to share with you, and we can make a lot of important observations about it. It's a mundane fact pattern, but people did pretty well on it, except for a tactical blunder that I'd like to point out. Here are the facts. Please listen closely. You were told that Burby owned 500 bales of cotton stored at a warehouse in Atlanta, Georgia. On February 1st, which they tell you is a Monday in the week, Charles, a cotton exporter living in Savannah, mails a letter to Burby seeking to buy the 500 bales at 25 cents per pound. And the letter concluded, quote, "Let me hear from you as quickly as possible. I must arrange for shipping space." You're then told that the course of the post between Atlanta and Savannah each way is but a single day. On February 12th, Friday of the week, Burby dispatched a letter to Charles, the buyer in Savannah, that read as follows: "You drive a hard bargain, but suppose it is the best I could secure. I'd be pleased if you could make it 25.5 cents. Suppose you won't, so the deal is on." Close quote. This letter was delivered to Charles' office at Savannah on Saturday morning, February the 13th, and he read it the following Monday, February the 15th. Charles did not communicate further with Burby. On February 17, Burby, the seller, who's not heard from Charles, consults you as to whether he has a binding contract. What do you advise him? Well, we ask ourselves, which of the 6 issues of contract law? Because obviously, if there's liability here, it's being predicated because on statements or promises made. It's the contracts question on the bar exam. Which of the 6 issues? Well, did the parties form an agreement? Go through your approach. Do you find an offer? You say, well, yes, they're putting them in quotation marks. Actually, if you showed me the page on this one, they're even indenting it on both sides. It's easy to find. Right? Well, they have made an offer. They stipulated here, didn't they? They said Charles sent an offer proposing to buy 500 bales of cotton at 25 cents per pound. So you simply state in a sentence that the offer in this fact pattern is stipulated. But please note the facts. That offer demanded a prompt response. Right? Step 2. At the time acceptance was attempted, was the offer still outstanding? The facts have already alerted you that this is going to be a problem. Why else did they put in the demand for a prompt response? It is doubtful if a 12-day delay in the face of an express demand by the offeror for a quick reply doesn't mean that the offer had died of old age. Step 3, if there was an outstanding offer, was there a defective acceptance? Again, the facts raise an interesting issue. Here you examine what the offeree Burby said and did. It is evident that the seller was not happy with the 25 cent per pound term. He expresses a wish and a hope for 25.5 cents, but immediately states, quote, "The deal is on." Here the facts have been deliberately muddled, but it would on balance appear to be a case of what we call a grumbling acceptance. This would be good enough to form a contract if the offer was still alive, because there never has been a rule, either at common law or under the UCC, that says that the parties have to be tickled pink with the deal, just that they objectively assent to the same terms. Now, if the offer was clearly dead on February 12th, the 12-day delay, the late acceptance would constitute a counteroffer to sell cotton. And as to this, you would have to examine the impact of the original offeror's silence. In this factual context, did it amount to acceptance since he had some duty to speak? A lawyer for Burby might argue that it is plausible that the seller believed the acceptance timely, and that at a minimum the other party should have the burden of speaking out and clarifying the situation. To my way of thinking, that's a pretty strained analysis. The moral is this. This entire question never went beyond the first issue of contract law. Did the parties form an agreement? Right? Almost everybody immediately saw it was a contracts question. No one had problems finding the offer. Right? And most people noticed the 12-day delay in the face of the explicit demand for a prompt response and discussed the question, was the offer dead, died of old age, so that there couldn't be a contract and agreement formed. And then, having said that, what they did was think that they'd mooted out all the other issues in the fact pattern, and they went on to the next question. Don't ever do that. If you are a judge, that would be the way you would dispose of the litigation. But I say that which we all know. In California, we cannot become members of the judiciary without first having become members of the bar. And one does not become a member of the bar by mooting out issues on the bar exam. If you concluded the offer was dead, noting the facts going on about the grumbling acceptance, you know they want you to discuss that. They're not putting that there just to pad the exam, to make the pages come out even at the bottoms. Right? And so you say, but assuming that a court were to determine that the offer was still somehow alive, we must discuss the content of the offeree's purported acceptance. Discuss every issue on an essay question. Every issue. Never moot something out. Now, I said I wanted to do two things. The first was to go over that question, and the second one we must do before we take a break is discuss a rule that doesn't fit too well in my 6-question construct of contracts. I call it the effect of adopting a writing, better known as the parallel evidence rule. Now, despite confusion in the minds of many courts, including, sad to say, the Supreme Court of California, the topic, the parallel evidence rule, comes up on the bar exam quite frequently. It is impossible. It's impossible to miss a fact pattern that raises this question. The facts will have to tell you that the parties not only formed an agreement, but that they reduced the agreement to a written expression. The facts will then have to go on to say that they are now litigating about the terms of that agreement. And one of the parties seeks to bring in evidence of some term or understanding which is not found within the four corners of the writing they created. Now, when they tell you all of those facts, they have invited your attention to the fact that you have the parallel evidence question before the House. Right? By the way, some people like to call it the parole evidence rule. That's how you get out of jail. There's no E in this word. Right? No E at all. But besides just the little point on semantics is the rule. It's an easy question to spot. That's the good news. And the better news is you can methodically lay the question waste by taking it one level at a time and get the maximum points. This is an easy thing once you understand it. First, make sure all those facts are there. And now you begin with the following systematic approach to your question, your response. The first thing I want you to ask yourself is this. Is there any evidence? Apparently it works better this way. Remember now what I just told you. A and B not only formed an agreement, but they've reduced it to writing. They're now in litigation. Somebody's trying to come in with evidence of a term of that agreement that is not in the writing. The first thing you must ask yourself is there an integrated writing? See, some people assume the parallel evidence rule protects anything in writing, even the ads on the inside of a matchbook. Silly, silly. The parallel evidence rule only protects what are called integrated writings. What is an integrated writing? That is an issue of the intent of the parties. Both parties must have intended the written instrument as the full and final expression of the terms of their agreement. If they did not create the writing with that intent, it is not integrated, and the parallel evidence rule has no application whatsoever. All right? Who decides whether the writing is integrated? It is the trial judge. Because now you can learn something very important about the parallel evidence rule. It is not a rule of evidence. It is a rule of substantive law. It has nothing to do with the credibility of the evidence. It has to do with whether the evidence is legally competent, not whether it's believable. All right? That's why the first thing the judge decides is whether the writing is an integrated writing. The next question that the judge looks into is to look at the evidence that the other party is seeking to bring in of some term or understanding, and the judge asks herself this question: is that evidence parole evidence? Yes or no? Now, what makes evidence parole evidence is not whether it's written or oral. Again, some people think that only oral evidence. It has nothing to do with the form of the evidence. It has everything to do with the time. Parole evidence is any evidence, whether written, oral, or chiseled in stone, of any promise, representation, or understanding between the parties who formed this integration, which was arrived at prior to or contemporaneous with the formation of the integrated writing. So you look to the time origin of the extrinsic evidence. What if the evidence is that a day after we formed this integrated writing, we added a term? That's not parole evidence at all. That's evidence of a subsequent modification. It isn't governed by the rule. Who decides whether the evidence is parole in nature? The trial judge. The third step of your analysis: if the judge has ruled that there was an integrated writing, and she has just ruled that the evidence that your client is trying to introduce is parole evidence, then the third question the judge passes on is the impact of the parole evidence on the integrated writing. Because the rule says that you may not use parole evidence to contradict, vary, or add to the terms of an integrated writing. What happens if the evidence doesn't have one of those three forbidden impacts? It explains an ambiguity. It defines a term. The evidence may freely be admitted because it has no forbidden impact. It's only variation, contradiction, or addition that may not be proven by parole evidence. Who makes that determination? The trial judge. If the judge determines that the evidence is presented in the teeth of an integrated writing, that it's parole in nature, and further that it has one of those three forbidden impacts, the jury will never know about it. The evidence will be excluded as legally incompetent unless the proponent of the evidence can bring it in, and here's the fourth and last stage of your analysis, under one of the very few exceptions wherein parole evidence may be admitted, notwithstanding the fact that it varies, contradicts, or adds. There are three exceptions I want you to remember for the bar exam. First, proof of fraud, the inevitable moral trump card. Whatever interest society has in the convenience of having the deal in writing, it has a greater interest in ferreting out an individual guilty of fraud. So you may always use parole evidence to prove fraud in the inducement, fraud in the factum, or fraud in the execution. I'll talk more about fraud tomorrow morning. Second, you may use parole evidence on a theory of what is called partial integration. In reality, that goes way back up to the beginning inquiry, in which the party who seeks to get the evidence before the jury claims that on the day a contract was formed, the parties formed a single contract, but, Your Honor, they intended this writing to cover some, but not all of the terms of that single agreement. If the judge believes that, then she allows the evidence to go to the jury on a theory that it was only partially integrated. Now, there are two tests for disciplining the judge as the judge makes that determination. The conservative test in jurisdictions that believe in the rule is the so-called four corners test. The judge will allow the evidence to come in only if this writing looks incomplete to her on its face. Then and only then could you come in with evidence of alleged further additional terms. Liberal jurisdictions who have been eating away and eroding at the parole evidence rule say that if the party who's offering can supply the judge with any credible explanation as to why we would have left this term outside the writing, I should be allowed to go to the jury, even though the writing on its face appears to be complete, having no obvious omissions. California follows the more liberal stand. And the last exception is called a collateral agreement. In a sense, this is the most dangerous exception of them all, because the lawyer who seeks to introduce the parallel evidence contends that on the day the parties entered the bargain, they formed not one, but two agreements. One agreement which they reduced to the formal integrated writing, and as to that, Your Honor, I have nothing further to add. I merely wish to be allowed to go to the jury and prove the terms of this collateral agreement. You can see that that exception could swallow the rule in the guise of an exception unless there was some way to limit it. And even California follows the following three-step analysis on collateral agreements. First, the judge must determine that the alleged second agreement is of far lesser importance than the subject matter reflected in the admittedly integrated writing. My niece one time put this in an essence as she rode home with me after attending one of these lectures. She said, I got that business about importance. Let's say that the integrated writing was a watermelon. Then the collateral agreement could be a lime. That's true. It must be of something of obviously lesser significance. The second thing, no term of the alleged collateral agreement can contradict any term of the integrated writing. And so if the integrated writing says this contains all the obligations of the seller, you couldn't establish by a collateral agreement that the seller had one last obligation to the buyer. And finally, there must be some natural daylight between the subject matters of these two agreements that makes it rational that parties would have considered them as two separate agreements, rather than what courts call being part and parcel of a single business deal. Again, who makes the decision that the collateral agreement is of lesser magnitude, does not contradict the integrated writing, and has some natural division between the subject matter, making it rational that it would have been regarded as a second agreement. It's all for the judge. We're going to take up the second of what I've indicated are 6 possible contract law issues we may confront at the bar exam. If, using the analysis we've employed, we have concluded that the parties formed an agreement, the next stage is to ask, is that private bargain a contract? As I noted in the overview in the first hour, an offeror and an offeree may form private bargains, agreements, but a contract is a legal status, and whether it has come into existence depends upon 2 elements: the presence of valuable consideration, bargain for legal detriment on both sides of the exchange, and the absence of defenses which would preclude formation. Let's begin with the element of valuable consideration. If we adhere to a minimum number of basic definitions, the material on consideration will reveal itself as presenting nothing to fear. Begin with the accepted definition of a contract, a promise or set of promises which the law will enforce or in some way regard as a source of obligation. Now, from that definition, it is clear that there are 2 indispensable parties to every agreement, the offeror and the offeree. There are 3 indispensable parties to every contract: the offeror, an offeree, and a willing court. It is the price tag for making the court the willing participant that we now look for, the element of valuable consideration. Right? Now, I'm going to give you a 4-step approach toward developing and searching for issues in this second of the major issues of contract law. It is as follows. First, as you look at the fact pattern, ask yourself this: do I find a bargain? Second, if the answer is yes, now look to the terms of that bargain. Does each of the exchanged promises or acts involve bargain for legal detriment to the promisor or the actor? That's really the heart of the matter. That's when you're testing for the presence of valuable considerations. I'll show you in a moment. Look to the terms of the exchange, sir. does each of the exchanged promises or acts involve bargain for legal detriment to the promisor or the actor? Third question, if the answer to question number 2 is no, one of the parties didn't incur legal detriment, right? Is there any substitute for valuable consideration present in this fact pattern? Any substitute? Truth to tell, that's really an inquiry, is this a promissory estoppel fact pattern? And fourth, if you have found a bargain and you have qualified it as a contract because there is bargain for legal detriment on both sides of the exchange, before you leap to the conclusion that a contract has been formed, ask yourself this, looking to the facts: do they reveal any defenses which, if established, would preclude formation and we'll talk about them. They're the so-called real defenses, which, if they are in the fact pattern, preclude the formation of a contract. Right? So those are the 4 inquiries developing the second issue. If I have concluded that the traders formed an agreement, is their bargain a contract? Now let's take them one at a time. We're talking about valuable consideration. Right? Let's define it. The definition is the one you heard in law school. It's the one in every case book, and it is emphatically the one in the PMBR outline. Valuable consideration may be formed either in my bargain for promise to perform any act, my bargain for promise to perform any act, or the performance of any act, which but for this bargain I am not legally obligated to perform. That's the key. My bargain for promise to perform any act which but for this bargain I am not legally obligated to perform. That's valuable consideration. But you may also find valuable consideration in my bargain for promise to forbear, or the act of forbearing, a course of conduct which but for this bargain I am legally privileged to pursue. I am legally privileged to pursue. So you see, it's the bargain for change in legal position and not any element of economic benefit that imparts value to valuable consideration. So there's 2 elements to valuable consideration. It must be bargained for, and there must be legal detriment. Now, the element of bargain was at the heart of the first big issue, finding the elements of agreement. It simply means that at the formation stage, the offeror and the offeree consciously exchanged promises with a view toward altering their legal rights and liabilities. You immediately see that a fact pattern that features a donative transaction could never be a contract, for there's no element of bargain. Past consideration is not valuable because it lacks the element of bargain. And by the same token, moral consideration, which is an act undertaken out of a sense of moral duty or obligation, is not valuable because there's no element of bargain. Right? So this element of bargain is crucial. It is what eliminates from the law of contracts all donative transactions, gifts, past consideration, and moral consideration. So a bargain is a synonym for exchange. Right? It's a straightforward but very crucial idea. Somewhat more subtle is the value element of valuable consideration. If there's one area where you can anticipate that the examiners are going to probe your understanding, it is your understanding of the concept of value in the law of contracts. And so we're talking again, I don't want to harp on it and be a pest, but I'll do it if I have to. We're talking about legal detriment. We're at the second step now of our analysis. If you found a bargain, now I'm going to go over here and I'm going to put a tiny diagram on the board because I write big and I haven't got much board left. But let's suppose you found a bargain formed in the bilateral mode. A and B, the offeror and the offeree, formed their bargain by an exchange of promises. You now apply the test at step 2. You look to each of the promises. And with respect to the promise that A gave to B, you ask this: did A's promise involve the promise to do any act which, but for the attempted bargain with B, A was not legally obligated to perform? If so, A's promise is valuable consideration. We now apply the test to the other side of the exchange. Did B bring valuable consideration to this bargain? We look to her promise and we ask, did B promise A that she would do any act which, but for the bargain with A, she was not legally obligated to perform? If the answer is yes, she also incurred bargain for legal detriment. I use 2 little interfacing arrows to indicate to myself that I have gone through this analytical step and I have found legal detriment on both sides of this exchange, and now, lo and behold, we have an executory bilateral contract staring us in the face. Just that simple. If the attempted formation was in the unilateral mode, the analysis is the same, though the facts are different. The offeror would have made a promise. I promised my neighboring lad $25. He couldn't accept by promising. He could only accept by doing the requested act. If he does the requested act, and thereby brings about an acceptance of my offer, is there a contract? Well, we look to his act. Did B do an act, a bargain for act, which but for the attempted formation of a contract with A, B was not legally obligated to perform? Yes, he did. He had no legal obligation to weed my yard. His act has the quality of legal detriment. And my promise rather obviously has the quality of legal detriment, but for the bargain with the neighboring lad, I had no legal obligation to give him $25. My bargain for promise to do so is valuable consideration. There is a contract in the unilateral mode staring us in the face. Now, the point that I want to keep emphasizing, because we keep forgetting it, not speaking personally here, but generically about our profession, we keep getting sucker punched on the idea that when we talk about value and valuable consideration, we're somehow looking at who got the better of the deal. We're looking for pragmatic advantage or economic benefit. It has nothing to do with it. Nothing to do with it. All right? Valuable consideration, as you can see from these examples, is a far, far more expansive concept than pragmatic advantage. I can show you legal detriment in both a unilateral and bilateral bargain, where the party who brings valuable consideration to the exchange not only is not injured in any pragmatic sense, he'll actually wind up advantaged, richer, happier, but it's irrelevant. To do it, I'd have to invite you to a little party that took place in Davis just last month, when my eldest son celebrated his 16th birthday. We had a little birthday celebration. You would have been most welcome. Had you come, you would have discovered myself, my esteemed spouse, 6 of his brothers and sisters, the birthday boy, and 2 other people I would have had to introduce you to. My sister, a truly gracious woman. More about her in a moment. And my brother-in-law, John, a person about whom I should say little. We are not close. Right? Now, as the evening festivities wore on, people were in a generous mood. And you heard my sister say to her nephew, William, if you will take a summer job this coming summer and manage to save $500 from your work in the bank, I will take you to the family home in Ireland when you graduate from high school.
You heard it. Now, let's assume that my son were to take a summer job, began to save $500. Would he have a contractual claim to have his aunt take him home to Ireland? The issue is easily resolved. First, did she make an offer? All right? She either made an offer of a bargain, or she just made a donative declaration, a gift with a string attached. That's a tough question. A tough question. But if a court were to construe her proposal as an offer to bargain, it is quite clear, and I've learned this the hard way, that my son would have brought legal detriment to the exchange, because you see, as I have found out 7 times, children have no legal obligation to work. Right? And so the act of working is an act which, but for the bargain with his aunt, he was not legally obligated to perform, and they also have no obligation to save. And the act of conserving something in a bank account. Therefore, my son would have brought legal detriment, though he was not injured in any sense. He benefited in the old Protestant ethic. He became familiar with work. He benefited in the economic sense. He's got $500 in the bank. He also has a contract right to go to Ireland, because it isn't morals and it isn't economics. It's bargain for legal detriment that we look for. But we have yet to hear from my brother-in-law. He was there. He has never been one to allow any manifestation of generosity on my side of the family to go unchallenged by a gesture of his own. And therefore he said, as the evening wore on, Willie, I hate that term, if you will promise and keep your promise, that you will not smoke, you will not drink, you will not take up with painted women or hippies, between now and your 21st birthday I will make out a check for $5,000. You were there. And my son made the promise, thus bargaining in the bilateral mode. Let us suppose that for the balance of his minority, 5 years, he keeps that promise. On the evening of his 21st birthday, which he would celebrate under circumstances neither his mother nor I would wish to know about, he makes a demand upon his uncle for the promised sum of $5,000. Has he a contractual claim? Now, I know my brother-in-law. Long on promise, short on performance. He will be looking for some means of evading liability, and he has arguments here. The test is whether or not his nephew brought bargain for legal detriment to the exchange. Let's go through. My son promised that he would not drink between now and the attainment of his legal majority. Is that legal detriment? No, it is not. It is not a bargain, a promise to forbear a course of conduct which, but for the bargain with you, uncle, I have a legal right to pursue. There is no legal right in a minor to consume alcoholic beverages in the state of California. What about the promise that he would not smoke during the balance of his minority? This one is in a gray area. It is actually illegal in California for a minor to purchase cigarettes, cigars, pipes, etc. It is not illegal for a minor to consume such things. But even if my brother-in-law the score would be 2 for him and zip for my son, there was the third aspect of this pattern of aesthetic abstinence, that he circumscribed his freedom of association during the balance of his minority. That clearly has about it the quality of bargain for legal detriment. And now we learn a lesson, and it will be particularly galling to my brother-in-law. So long as any element of the proposed exchange carries about it the quality of bargain for legal detriment, it is sufficient to render binding the entire promissory obligation of the other party. So if only one of those 3 matters was clearly legal detriment, the uncle is not liable for a third of $5,000. He's liable for $5,000. Because you see, at law, courts are splendidly disinterested. Parties are free to make their own bargains, foolishly or providently, seeking where they believe their advantage to be. All the law asks is, was there bargain for legal detriment on both sides of the exchange? If there was, there is a contract. Is there any exception to that rule that I just laid down? That courts are absolutely disinterested in the economics of the exchange? Yes. But it is so narrowly drawn as to leave 99.9% of the cases within the general rule. The exceptional circumstance deals with transactions that involve the abuse of some socially protected relationship. We call them fiduciary relationships or confidential relationships. If the bargain between A and B is in the face of a fiduciary relationship, courts will insist that there be more than merely legal detriment. They will scrutinize the pragmatic advantage of the exchange, looking to decide whether it was a bargain fair in its terms. What is a fiduciary relationship? It is a formal relationship of trust and responsibility, defined by law. Examples would include a guardian and his ward, a lawyer and her client, a trust beneficiary and the trustee. These are formal relationships of fiduciary qualities. The law will police the bargain from the vantage point of looking out for the interests of the protected party and will actually examine the pragmatics of the exchange. Confidential relationships are not established by law. They're established by human beings. They can be any human pairing, featuring trust and dependence on the one side, and the assumption of dominion and influence on the other. If a confidential relationship obtained between A and B, again, the law will look beyond the issue of legal detriment on both sides of the exchange to scrutinize it for fairness of terms. But those two species of relationships, fiduciary and confidential, are the great exceptions. For all other bargains between A and B in the English-speaking world, the rule is, did you find a bargain? Did it involve legal detriment on both sides of the exchange? If it did, we have a contract. Now let me erase this material and replace it with a diagram and some terms that may be useful to you in structuring your analysis and facilitating a quick outline in your own mind of how you're going to write an answer to one of these questions. Because there's some vocabulary I'd like to share with you. In discussing issue number 2, courts use 3 critical terms. Want of consideration, failure of consideration, inadequacy of consideration. Now, it's critical that you be able to master these 3 terms, and it's very simple. You doubtless already know them. Want of consideration is a defense to the formation of a contract. If it can be established, there is no contractual relationship. Want of consideration involves proof that at the formation stage of the offer and acceptance, the other party incurred no element of legal detriment. The party who gave a valuable promise has an absolute defense against liability to perform it. He merely cites want of consideration. There is no contract. It's a defense to formation. It is the trump card in all contract litigation. By contrast, failure of consideration admits that a contract was formed. At the stage of offer and acceptance, I am admitting that the other party incurred bargain for legal detriment. But I am now contending that the other party is in present material breach of the contract. And the consequence of his being in present material breach is that the consideration has failed.
Please stop the machine at this point and turn the cassette over for side 2.